Hello, my true crime lovelies. How are you? I hope you are well. I hope you are as lovely in life as you are in my mind. We are going to go over the existing parenting plan for Boone v. Boone. So, Sarah and Brian, or technically Brian and Sarah, because he is the petitioner. Now, this is the current agreement that they had from when they were divorced. So, their dissolution of marriage was in May of 2018. And this was the existing parenting plan that we're going to review. I wanted to review it in anticipation of their proposed parenting plans that will be due now in family court, where Brian has to submit a plan and Sarah has to submit a plan, and then the court will merge the two, all things considered, right? And then they'll come up with one official parenting plan that they will have to abide by. Now, that was my first intention in doing this, but in preparing for that video, I noticed that Sarah is not even following that current plan. So I wonder, because Brian's attorney is pretty sassy, if he is going to call that out in the proposed parenting plan, or how that will be addressed, if at all. Maybe it's moot and they don't want to, but it just seems like if you're going to come up with a new plan, you would want to point out, hey, and by the way, judge, we had agreed to a plan before without a judge, just amongst themselves, and then submitted that to the court, and she wasn't and is still not following that plan. So let's put, I don't know, can you put penalties in there? Who knows? But let's get into what they currently have. I'm going to run the intro. I'm going to thank my members and thank you for being here with me. I appreciate you, and I will see you on the other side. All right. So I brought back our Florida v. Boone backdrop, one of our backdrops, because I do want to remember George. I feel like sometimes he gets lost in all of that, and I am a contributor of that. So I want to rectify it. All of these problems that Sarah has, the problems that she's crying wolf and victim for, are all for her own doing, because she had zero compassion for someone that she proclaimed to love. If she had shown a modicum of humanity and listened to his pleas and let him out of that suitcase, she would not be in the situation that she is in. So for all of her cries of wrongdoing, of how she's being deprived of her son and can't see her son, guess what? George doesn't get to see his son at all, ever. And we've seen from the call logs, she definitely talks to her son. So she just likes to be the victim. Anyway, let's get into this parenting plan, y'all. So this was from 2018, filed 5/9 of 2018, the parenting plan. It is submitted to the court with the agreement of the parents. Both of the parents are there. Yes, sir. And this is what I was saying. Like, they agreed outside of court and then submitted a completed document, and then it was accepted by the court, right? So they didn't have to have like Sarah's version, Brian's version, the judge weigh in on it, which actually saves money in the long run, because you don't have to pay, lawyers charge different amounts when arguing in court. Anyway, Sarah doesn't care. Excuse me. She's all for spending Brian's money, apparently. So shared parental responsibility. It is in the best interest of the child that the parents confer and jointly make all major decisions affecting the child's welfare. Major decisions include, but are not limited to, decisions about the child's education, healthcare, religion, and extracurricular activities. Sounds reasonable. Day-to-day decisions. Each parent shall make decisions regarding the day-to-day care and control of the child while the child is with that parent. So this child has been with Brian since February 25th, 2020. So he gets to make all the day-to-day care and control, the decisions regarding the day-to-day care and control, per their current agreement. Extracurricular, parents must discuss and mutually agree to all extracurricular activities. The parent with the minor child shall transport the minor child to and or from all mutually agreed upon extracurricular, providing all necessary uniforms, equipment, and within the parent's possession. Uniforms and equipment within the parent's possession. I added an and, which changes the meaning. So, prohibition on alcoholic beverages. The wife shall not consume alcoholic beverages when the child is in her care. In the event this provision is violated, the time sharing shall be supervised only at the father's discretion, unless and until the mother completes a treatment program. So I think that was huge that she agreed to have that in the agreement, right? Because she's sort of admitting to having a problem, or at least admitting that if she cannot control herself with alcohol around the son, in order to regain like non-supervised visits, well, one, she would lose the ability to have one-on-ones. There would be supervised, and in order to regain having non-supervised, she'd have to do a completement treatment. And a treatment program for alcoholism. So recognition of children's rights. I'm only going to read what was highlighted, but obviously what I've highlighted, but the rest is on the screen for you. So number 3, because this is where I feel like she's violating. The child has the right to be free from being present during the parent's personal battles or being used as a spy, messenger, or bargaining chip. So I am going to show you some text messages where this happens. I know I haven't read them before, but this is to like just get to the truth of the matter, right? Because I feel like Sarah and Flying Monkeys like to pretend her behavior is something other than it is, and we're just going to tell the truth and shame the devil. So the child has the right to not be questioned about the other parent's private life. So if Brian is smoking cigarettes, if Brian is buying alcohol, if Brian is ordering Uber Eats, Sarah has no right to question the son about that, and vice versa. But I don't get the sense that Brian is doing that. I'm not trying to like ignore whatever Brian's behavior is. He just doesn't have his out on Front Street. So the child has the right to not hear parents speak ill of each other, nor to have to hear about the difficulties with the other parent. That is definitely happening. There are messages where she sends to her son, like, out of credits, can't message anymore. That clearly has to be a message to the dad through the son. So he's being a messenger. And he's hearing about the difficulties that Sarah perceives with the other parent, right? Because I know she doesn't expect the son to send her money. Like at the time that she's sending that message, he was 13. So why are you telling him you're out of credits? That is a grown-up problem. And it's actually implying that it's Brian's responsibility to send her credits when in fact it is not. Like, ma'am, you are a whole grown-ass woman. If you don't figure that out, and what are you doing with all the money people are sending you? We're going to look at her numbers too. In 1 month alone, she got something like $760, while for the 12 months of that year, she had only spent $360 in commissary. She kind of reverse engineers in her financial statements where she's asking for money for collect calls, but really what she's doing is asking Brian to allocate $200 out of his budget so that she can make collect calls, right? Because he can't give her, well, maybe, you guys let me know. Some people have been in jail and or prison. Like, is there a card someone can send you and load it up and then you call from there so the call's not collect? How does that work?
Let us all know.
Number 10, the child has the right to be a child. Amen. To be free from parents' guilt and not to assume adult or parent roles. And she guilts him a lot in those text messages. I'm only going to read 4 or 5. They're powerful enough that you'll get the gist. So notwithstanding the above, each parent shall be responsible for obtaining records. Oh, wait, I wanted to read this even though I didn't highlight it. So information sharing, they both shall have access to medical, school records, etc. Sarah seems to be under the impression that Brian owes it to her to get those records and send them to her, when clearly it says, even though you have the right, Each parent shall be responsible for obtaining records and reports directly from the school and healthcare providers. So Sarah has to call the school. Like Brian has to facilitate that in saying like, this is his other parent. She has rights per our parenting agreement to have access, right? That's what the above paragraph is saying. But she's got to call, she's got to write. And if there's a fee, she's got to pay. It just says it here, plain English. Each parent shall be responsible for obtaining records and reports directly from the school and healthcare providers. It doesn't say, if you unalived your boyfriend by not letting him out of a suitcase after he begged you and you end up in prison for the rest of your life, then the other parent has to help you get these records. And nowhere in this parenting plan does it say that. Both parents shall have equal and independent authority to confer with the child's school, daycare, healthcare providers, and other programs with regard to the child's educational, emotional, and social progress. So the things like where she was complaining about the dentist and the dental work he had or hadn't had done, Brian had or hadn't had done for the son, call the dentist and find out what work was done. Write them. However, both parents shall be listed as emergency contacts. So obviously that's moot because emergency contact means like, we need you to get to the school right now, or we're in a medical crisis. Is it okay if we give XYZ? One, they can't call her for her to authorize any medical treatment. And two, she can't get to the school right away. Why?
Oh, because she's left her boyfriend in a suitcase.
So school calendar here, it says they'll follow school calendar of Orange County, Florida. So that would just need to be updated because I believe they've moved out of Orange County in their new location. So that would just a little change. This was their original holiday schedule when both people were, neither person was a convicted felon. So Mother's Day every year, she got the son. Father's Day every year, he got the son. And then they did even years and odd years for Easter, Memorial Day, 4th of July. So even years 0, 2, 4, 6, 8, right? We all know those. And then odd, 1, 3, 5, 7, 9. So years ending in those numbers. So like we're in 2025, it's an odd year. So it would be Easter, Brian would have him. Memorial Day, Sarah would have.
I almost gagged trying to say mother.
Sarah would have him. 4th of July, everybody gets it, right? Thanksgiving, the child shall be with a father for the entire Thanksgiving school break in even numbered years. So this year's an odd year. Sarah would have had him for Thanksgiving. His birthday, they both get access on his birthday, irrespective of the year, every single year. And the same with the parents' birthday. So on 10/10 of every year, Sarah gets the son. And I don't know when Brian's birthday is. It's May something. He gets the son. Monster truck? Do you need help with your monster truck? Spring break, the party shall divide spring break. Apparently, they get 2 weeks in Florida because it says this parent who is scheduled to have the first weekend of spring break. Oh, no, I'm misreading it. First weekend in the alternating rotation shall have the child from school dismissal until 6 on Wednesday. So they split it depending on if it's an even or an odd year determines who starts the week. And then summer break. Each parent has the right to 2 uninterrupted weeks. Now you'll remember, well, if you're new, you would not. I'm going to tell you either way that Brian took the son away for a vacation for 2 weeks, and Sarah acted like he was committing a crime against humanity. It's right here in the parenting plan that he gets to do that. Not that she could take him away anywhere. She was just upset that nobody was calling her while it was happening. Like he couldn't have 2 uninterrupted weeks with his son, but it's right there in the parenting plan. Education, child shall attend school in the father's school zone. So that made sense because Sarah, it's clearly there's like little markers here of like how Sarah is not responsible. And so even when she was free, Brian still bore the brunt of parenting. And then the day, so I know a lot of people have said, why did he have to pay her child support if they were sharing custody? Well, he had 1 less day than she had, and that factored into their calculation. So that's how he ended up owing her $100 a month. Probably also factored in that she didn't have a job and was living off of spousal support, and that spousal support was meant to go for her well-being. But if her house is in order, the $100 really isn't like to cover electricity and whatnot. It's like maybe extra food, maybe extra gas for any extracurricular activities. I mean, because $100 is not a lot. So it was just like to cover kind of the difference of having him there for that amount of time. Communication. What's happening? Where's your monster truck? Vroom, vroom. All communications regarding the child shall be between the parents. The parents shall not use the child as a messenger to convey information, ask questions, or set up schedule changes. The parents shall communicate with each other by text, telephone, or email, or in person. So they did not have Family Wizard. Remember, I asked about that before. And then between parent and child, keep the information. Contact current. Ow. Speaking of communication with child, please hold.
Mommy.
Okay.
Mommy.
Yes.
Mommy. Are we?
You have an owie? Oh. You keep bumping your head on there. So the forms of communication they can have: telephone, electronic communication. It shall not be monitored or interrupted by the other parent. Electronic communication includes telephone, email, webcams. Say what? Video conferencing, equipment, and software or other wired or wireless technology. So I do want to call out, in the video visits at the jail at Orange County, Brian was always present, like the logs that we reviewed. I think that may have been a requirement of the jail, like to not have minor children unaccompanied on those visits. I'm not sure, because it goes against what the parenting plan is, but obviously the jail rules would supersede that, right? So changes or modifications of the parenting plan. When the parents do not agree, the parenting plan remains in effect until further order of the court. Any substantial changes to the parenting plan must be sought through the filing of a supplemental petition for modification, which Brian filed in 2022. Any relocation is subject to and must be sought in compliance with Section 61. So he did that in 23 and it was approved. Disputes or conflicts. Whoa. Parents shall use mediation or other dispute resolution methods and assistance, such as parenting coordinators and parenting counselors, before filing a court action. So Brian did reach out to Sarah. Sarah disagrees with this, but he did reach out to Sarah through his attorney and attempt mediation in 2022. And she came back. She wouldn't give a date. She came back, she has cancer and can't plan. And then she had a bunch of legal questions, which his attorney is not required and probably not permitted. Like, why would you ask for legal advice from your opponent's counsel? And so then they filed for, they being Brian and his attorney, Joshua Martel, filed for skipping the mediation because she wasn't cooperative. That motion was granted. Not just because she wasn't cooperative, like the way the motion is, or the way the order is worded was like also because of the circumstances, like making mediation difficult. However, Sarah keeps coming back with asking for it in the current documents, like in 2025, and that's already been sorted. Like the judge is not going. So she just denied it this last time, Judge Jackson. There was a recent request for it and it was denied, but I don't know why Sarah can't take no for an answer. Like, it's been denied since 2020. In one of Sarah's motions in either late March or April, she says she's asked for it again, and she explains how she was cooperative last time. And it's like, ma'am, anybody who reads that letter, it's clearly you were not cooperative. You were resistant, controlling, and just unreasonable, quite honestly. So anyway, that parenting plan was signed April 2018. So that's what they're currently under. Then I want to go to the text messages so we can just look at.
Was she really following the plan? She loves to bend the truth.
January 2nd, 2024, she sends this to her son with the subject line, 2024. I'm going to change the view on this because it looks like it might be a little squished. We're going to go to this format. Sir, what's happening?
Mommy.
Yes. Happy New Year, question mark, or just New Year, question mark. I'm praying you will help make it a happy New Year. I keep trying to call you on your phone and still it goes directly to voicemail. I really do not want to call Brian, as I've said in the past many times. I was hoping you would actually listen and care and make an effort just simply to have your phone on and charged so I can talk to you. Why, son? It's not like I'm asking you to grow a third arm or lasso the sun. Just answer your phone. I hope one of your resolutions, if you have any, is to be nicer and respectful to your mom and to understand my feelings. Yes, I have feelings. And how much you crush them by not caring enough to simply plug in your phone. Okay, so before we go further, let's unpack that, right? She's putting her happiness in his hands. No one else is responsible for your happiness except you. So the fact that she's saying, I'm hoping you will make it a happy new year, this is guilt tripping, right? Somehow her life is not happy because he's not doing, or she is unhappy in her life because he is not doing things to make her happy. Horrible burden to put on a child. And it violates, let's see, free to be a child, free to be, let me go back to this. I want to make sure I quote this right. The child has the right to be a child, to be free from parents' guilt and not to assume adult or parental or parent roles. Would you make sure it was on if Addison called or Mary or anyone other than me? If you are choosing not to talk to me, I wish you just man up and tell me so I could stop looking like the fool you are making me out to be by calling you just to be yelled at, called names, or hung up on. If you have nothing to say to me, or care enough to include me and share your life, just be honest and say so. You are my son. I am your mom forever, no matter what, where, when, why, no matter anything. You can't delete, erase, blot out, omit, change, or remove. Stop being mean to me and not caring. I'm already going through so much. Then to be disregarded and spat on by you is unspeakable. And for no reason. Do you delight in making me feel worse? Does it make your day knowing you make me cry and feel worthless to you? Who am I to you? Really ask yourself that. Punching bag? Daily joke? Unwanted friend? That's how you make me feel. Know that, son. I can't make you care. I can't make you love. It's your choice. Yours only. New year, new start, new everything. Your choice. Don't forget about me. Love always. Who am I?
You are fucking unhinged, lady. That's who you are.
Oh my God, I can't believe she sends that to him. So obviously, if we go back to the parenting plan, just to keep us all grounded, the child has the right to be a child, to be free from parents' guilt and not to assume adult or parent roles. So she is violating that all day, every day. Yeah. I mean, she just is violating it. She's taking away his right to be guilt-free. She's guilting him, saying, you have to talk to me. You should want to talk to me. She doesn't want to sign off like your mother. Instead, she signs out with the guilt. She signs off, love always. Who am I? You're crazy. You're the crazy lady that's bothering him. That's who you are. Okay, so on the 14th of January of 2024, the subject is all caps, plug in your phone. I've been trying to call you on your phone the last couple of days, and it just rang and rang, then voicemail. Now it just goes directly to voicemail.
Because he don't want to talk to you, lady.
Please make the effort to plug in and charge your phone and make sure you have with you. It's not nice to me to not be able to talk to you because it's not on, especially with all the time off you've had for the holidays and the long weekend now. What is that, MLK Day? What long weekend, January 14th? She's guilting him. Now you have more time. You should talk to me. Only in Sarah's mind does that make sense. Not to be free to play with his friends, to play video games, or do whatever else the rest of children do in America and worldwide when they have a holiday. It's not more time for you to be free. It's more time for you to talk to me. 2, I've explained my reasons for not wanting to call on Brian's phone. Remember, and what might those reasons be? Something to do with Brian, something negative to do with Brian, which violates the parenting plan. Remember, if your decision is for me to not be a part of your life and keep trying to talk to you, just say so.
Just say.
Your response the last time I asked you was that you wanted me to be. So she's harassing him and she's confronting him on the phone, right? Because she's saying the last time she asked. Why is that even a question? His actions are speaking. If he's not picking up the phone, he doesn't have time to talk to you, or he doesn't want to talk to you. I mean, and am I overthinking it? Am I oversimplifying it? Maybe not overthinking. Like, if I keep calling someone and it goes to voicemail, I would eventually stop calling them. Do you know? Give them time to hear the voicemail and call me back. I guess he can't call her back, but he can tablet her. You notice we don't see one tablet message, and I don't see any redactions because I thought about that. Like maybe the state attorney's office redacted some of that, but you would see like a redaction mark. There's no missing. Although I will say, can you guys see this? I was supposed to have evidence number 424 through 891. I don't have through 891. So maybe after September, all of those were with her son. I doubt it. I did, because Hear Me Out pointed that out to me. I did send another letter to the state, or another email to the state's attorney office asking like, hey, where are these other messages? So we'll see what they say. But anyway, just her conversations with her son are not mother-child conversations, right? You're confronting him on the phone. Does he want to talk to you? You're telling him, why aren't you answering? Turn on your phone. It's like very, very controlling, very giving, like, you are a thing that belongs to me and should submit your will to me. Don't have fun on your extra day off and long holidays. Make time to talk to your mother like it's an obligation. He should want to talk to her. If he wanted to talk to her, he wouldn't need to be prompted, let alone spoken to this way about not talking to her. Your response last time I asked was that you wanted me to be. I would know from the lack of effort and intention to make possible from you. What else can I do? Honesty and effort. Not asking much, but missing out on talking to you. I'm sure he's so excited to hear your conversation with these text messages. Oh, those phone calls must be so delightful with you confronting him and all. Not asking much, but missing out on talking to you, my one and only son. Love, your one and only mother. Please plug in and charge your phone. Keep with you so we can talk, please. So now it's not only a landline, it's a mobile phone. So wherever he is, whatever he is doing, her expectation is he is meant to pick up that phone and talk to her. He could be at an ice cream bar, a soda shop with his friends, and he's got to step outside to hear her ranting. Okay, the 15th of January at 9:44 p.m. Love you is the subject line. I missed talking to you on the phone tonight after calling 3 times. It's giving mommy dearest, Sarah. It's giving mommy dearest. I love you very much. I hope your day back to school is great. I'll call tomorrow. Love you forever. To her son on the 18th, all caps, trying to call you. Your phone goes directly to voicemail, still trying to call. Why can't you make sure it's charged, on, and with? Please know it is not me not trying to talk to you.
Double negative. So It is you.
Effort and love, ? Then we have on the 19th at 10:04 p.m., which is a school night, I'm guessing, since he went back to school. What do we say on was it the 15th? It might not be a school night. Either way, it's late to be trying to call a child, a 13-year-old, at 10 o'clock at night. At least in my mama's house, 8:30 was the bedtime. Now, I had a phone in my room and I had my own line, so I may have been under the covers. This is pre-cell phone, the little princess phone.
You did not want the wrath of mama if you were busted.
I just tried calling yet again. Why can't you? Rather, why won't you make sure your phone is charged and with you to talk to me? For how many times I have to ask you and Brian, I keep using my credits that cost 50 cents each to remind you. Please plug in, charge, have with, love and effort, ? If that's not guilt, I don't know what is. And you don't have to use your credits. You're choosing to use your credits.
You could stop fucking calling him.
And then this one on the 20th, all caps subject line, no credits trying to call you. All caps message, no credits trying to call you. This is immediately, it's 1 minute after she sent the identical subject and message to Brian. What is the child supposed to do about her having no credits? I put these P's for parenting plan because I'm marking this up. The other ones, obviously, I'm not reading. February 10th, 1:37, subject line, all caps, I love you. Please answer your phone. Message, I love you. Please answer your phone. Heart, keep trying. Be you, love you. Heart, smile, D-smile. So these are where the messages were getting cut off. Let me just look and make sure I'm not missing any of the P's. I didn't read any of the sunny day scriptures. I find them offensive because she's reading scriptures to him, but this one was interesting. All caps, you're the one in charge. I've come to the frightening conclusion it is my personal approach that creates the climate, and it's cut off, so I'm going to try to fill in words here so we get the essence of her message. It is my daily motivation. I possess tremendous power to make life miserable or joyous. I can be an instrument of inspiration. I can humiliate or humor, hurt or heal. And as something decides whether a crisis is escalated or de-escalated, and a person, we decide we treat people as they are. We make them worse. If we treat people, something became what they are capable of becoming. Johann Wolfgang. I'm not going to be dehumanized by you any longer. This is what she's saying to a 13-year-old. Let's hear it again. I'm not going to be dehumanized by you any longer. So she's telling him, you have been dehumanizing me and I have been allowing it. And now this is where it ends. 13-year-old son of mine. It's a choice. Something gifts whenever your father, probably the Christmas gifts. You'll get your Christmas gifts whenever your father decides to order. It's the middle of February. No card, or I'll get your card whenever it comes in the mail, and you eventually check the mail, or you'll get the card. So for those of you guys who didn't go through all the text messages with us, and I don't blame you, there was this ongoing thing of she wanted Brian to order Christmas presents for the child that were from her. And she sent this list that was early in the text messages. I had a whole separate PowerPoint for each of the gifts. One of them was like a fish in soap that looked like it was floating. They were not really age appropriate for a 13-year-old. And the thing was, not only was he to order it, but then he had to schedule a video visit so that she could see him open the presents and see his reactions, because that's not weird. What if he didn't have the appropriate reaction? Was she going to lose her shit? That's what she's going on about. But it kept getting delayed. Even if he had ordered them, the son was prohibited from opening them until they had the video visit where she could see, like real creepy stuff. It's all about control for her, right? It's the middle of February card, whenever it comes in the mail and you eventually check the mail, and I have no resources, family, or money. So I haven't been reading them, but if you for shits and giggles, you can go back and slow this down. Philip Paulson is her youngest, or her younger brother. And she's been hitting him up for money. So he's sending money. I don't know if Lana is sending money at this time. Christina is definitely sending money. Philip is family, so I don't know why she's saying she has no family. Her son is family. Like, so that's like insult to injury. That's one of those moments of,
Well, what am I? Chopped liver?
so she's always exaggerating. It's always hyperbole to enhance her victimhood, right? So I have no resources, family, or money. You have all and do nothing. Something this year. Make a video visit after telling me you were going to. You're in any way. And after last year lying about making me a card, so she's calling her son a liar, for something the father won't even let me have a hot meal. So she's just disparaging the other parent, won't let her have a hot meal. He's not responsible for feeding her. She is in the care, custody, and control of the state of Florida. So I'm going to just share this tab. Number 6, the child has the right not to hear parents speak ill of each other, nor to have to hear about the difficulties with the other parent, right? The child has the right to see his or her parents being courteous to and respectful of each other. So there's another instance where she is violating the parenting plan. So not have a hot meal and keeps lying. So now she's called the son a liar and the father a liar. He did something to want to be a weatherman when you were younger. Here's your chance. Something about you. Know that you're the one in charge. Anytime we've heard her utter the words know that, it's never in like a positive conversation. So it always seems like a threat. So I feel like now she's threatening her son. Here on 225, she writes, the subject is all caps.
I tried calling 9 times today, 8 yesterday.
Just for you, this is the message, just for you to yell and not care as usual.
Well, then stop calling, girl. Take a hint.
While typing on your computer, something stupid, uncaring response your father gives me. So now we're disparaging dad again. Then hangs up on me and I don't get to talk to you. What would you do if I didn't care? Probably breathe a sigh of relief, because if this is Karen, I don't want you to hate me.
Listen.
Why do I have to something? The difference with that is that I will always care and never something me, your mother, nonetheless. I tried calling 2 more times tonight. This is at 8:45 that it's coming in. Like I tell your arrogant, mistreating father. Feel good about yourself. Hope you have a super week at school. I'm never important enough for you to tell me what's going on with you. That's what you make me feel like. Thanks for the Valentine's Day card. Have decided to make them for me after telling me you'd think about it, instead of like last year with you lying to me with your adult father, which is redundant. Like, why would he have a child father? But I think she likes the extra word. She thinks it makes her sound smart. It underscores her ignorance. He's 13. Like, how could he have a child father? I mean, I know there are fathers that are underage. Luis Rivera comes to mind. He became a father at 13, but by the time the child was 13, he was 26. So he was an adult. It just doesn't make a lot of sense. Oh my God. Okay. Where was I? That you made me a card, then mailed it to me. If I wasn't incarcerated, would you treat me the same way? You know, this is temporary, right? The difference with that is that I will always something the way you treat me, your mother, nonetheless. Do not ever. It's cut off the way that it's printed. I know someone was like, oh, you can. No, I can't. It's just a PDF. It's cut off. That's all I can do. Wait. Then she has this 3-page rant. So this is on March 9th, and I'm calling it a rant because this would frighten me as a 13-year-old child. I would definitely feel like something was wrong with the person sending me these communications, right? So subject is so much. And then she writes, I love you, heart. So they have a maximum of 35. Is it 3,500? It's either 3,500 or 35,000. I'm drawing a blank. 35 something characters. So she writes that, and these are on the size of the pages are the next size up from legal, which I think is 11 by 17 is legal, whatever that next size up is. Like if you're doing architectural drawings, that's the only thing I can think of that I print at work that has that, like structural drawings. Anyway, so there's the rest of this page with the I love you heart. So evidence page 0475. Then we go a whole other page with just I love you heart, evidence page 0476. Another one, evidence page 0477. Another one, evidence page 0478. Oh, but she's not done. And then we go to the top of this next evidence page. Like, you've sent all this vitriol and then you've sent I love you. I hope this child is in therapy, because I hope that he doesn't think when he gets a significant other that this is normal, that this is how love is expressed. To berate, belittle, name call you, and then,
or as we would say back home, call you out your name.
And then love bomb you. Okay, this is the last one. This is to Brian. This is the only one I'm going to include, but I thought it was important. She repeats herself, but it's nutty.
She's nutty as a fruitcake.
Subject, all caps, regarding our son. Important. And then the rest of this is all caps. Do not put our son in the middle of any of our something did last night. Do not put our son in the middle of any communication as you did last night. Do not put our son in any of our adult communication. So it's interesting because we get more of it because she repeats herself, even though it's cut off. Of our adult communication as you did last night. We agreed on the forced phone call I had to make to you, something of my messages asking about his Christmas presents. We're in March. We're still talking about Christmas. Ongoing 4 months later, where he and I are still trying to open all of his gifts from me. Be a responsible, caring adult. Do your own dirty work and lying. Do not include my son in the past and attempted to do last night. He does not do something part of any of your cruelty, disrespect, viciousness, and something does not want to be a part of any of your cruel and something and lies against me. He does not want to be a part of your cruelty, disrespect, viciousness, and lies against me. You talk to me, not my son. You tell me you are not answering something, threaten me to hang up on me, not my son. You call me. He walked away from you after stating multiple times vocally he does not want to be in the middle of anything and should to hang up on me after you told him to. You picked up the phone because he did not and was not going to. That was the something hung up on me. No communication or cooperation. Do not put our son in the middle of any of our. And then she goes on. He does not want to be a part of the viciousness and lies again. Any of your cruelty, disrespect. Do not put our son. So I don't know about you guys, but to me, it sounds like they were arguing, which would violate the parenting plan. Right? I don't know who started it and what was going on, but I do know that it violates the parenting plan, which has the child has the right to be free from being present during the parent's personal battles or being used as a spy, messenger, or bargaining chip. The child has the right not to hear parents speak ill of each other, nor to have to hear about the difficulties with the other parent. So left, right, and center, ma'am is violating the parenting plan. I mean, she just is. There's no, let me know if you guys think I'm reaching, but I feel like that is pretty cut and dry. So then I want to go on to her motion to compel disclosure because she's accusing Brian of lying with the current court. She is, what date was this? May 30th. Motion to compel petitioner for amended discovery responses financial affidavit. So respondent has evidence needed to be brought to the court's attention where she believes the petitioner is knowingly and willfully misleading the court. Where did she get that evidence if not from the son? The shared minor child has indirectly made statements regarding the petitioner having a real job and it's not doing contract work anymore. So at this time, the son is 14. I don't know if at 13, 14, my daughter would have known the distinction between what an adult would call a real job versus contract work without prompting from an adult, right? He doesn't file taxes. So he doesn't know the difference between a W-2 and a 1099. The appearance of the work looks the same. You would either go off to a job and come home after a set amount of hours, or you would work at home, start at a certain hour and end at a certain hour. I don't know that that's visually distinguishable to a child, right? That's number one. But she's alleging, I'm going to change this because I see this looks tiny again. So she's alleging that in passing, the child has mentioned this, which when she's saying indirectly, it implies without prompting. But again, I'm questioning how would he know that without prompting, the difference? And the not doing contract work anymore, oh, she of too many words, anymore relative to when, because there's nothing on the record to say he was ever doing contract work, right? We have his 2018 filing where he was a computer programmer. And then we have his 2022 filing where he's unemployed but looking for work as a computer programmer. Also, there's a clear thing, and this is another thing between Sarah and Peter. They're writing that Brian can't fall back on Rosenblum v. Rosenblum, which is what stayed him having to pay anything until his motion was heard, that he can't rely on it because he submitted nothing of financial hardship onto the record, which is a lie. He submitted it in 2022 saying he was unemployed. If that is not a financial hardship, I don't know what is. Sarah and Peter don't see that, and they are continuing to pursue money from a single parent. I know you want receipts. I got you. Tanika, where are you getting that from? From the court docket. So this is filed. Can you guys see that? 8/25/2022. This is filed by Brian. Yeah, you can see it. Long form. So here he is unemployed. Describe your efforts. He's currently looking, and there's the range. This was filed with the court, e-filed on 8/25/22. So when Sarah alleges that he's not shown any change in financial status, it's not true. He was not working, right? And then we're going to share this one. When she says he stopped paying, so this was filed October 2023, 2023 at 11:51, the case management conference where they had a hearing. So the court cannot hear the respondent's motion for contempt. So she filed a contempt motion saying, hey, he's not paying the alimony. He's violating the court order. Do something about it. Cannot hear the respondent's motion for contempt regarding unpaid alimony until after a final hearing is held on the respondent's petition for reduction or elimination of alimony. See Rosenblum v. Rosenblum. So he wanted reduction or elimination. He filed that in 2022. We're now at the time of this document, 2023, and the court is saying can't hear it until we hear this other thing, right? So you're probably like, well, what's taking so long? Well, hold on, we're going to get there. Because that's what Sarah said. Respondent expressed frustration at not having matters heard and not being adequately informed about her case. So the court explained that the family case is on hold pending the outcome of the respondent's criminal case. And then 10, the court finds that permanent decisions regarding relocation and alimony should be postponed until the adjudication of the respondent's criminal case so that circumstances are clearer. If you're saying, wait, he already relocated, it was a temporary relocation. If you go back to the family court letters, you'll see Sarah had a whole rant about that. It's not temporary, blah, blah, blah. But it was filed as a temporary motion, a final decision to be made after, which now that I think about it, I don't think that's in the current what's going to trial in August. I might be misremembering. But so when Sarah and Peter filed the thing saying the motion that they have that he should be paying until, no, he shouldn't, because the contempt cannot be heard until after the final hearing on his motion. So that motion will now happen 8/25. It's actually going to be a whole trial. But yeah, so she's frustrated, but nothing can be done. The court cannot move forward until her criminal case is done, which now it is done. She knows this. I don't know why she's gaslighting Peter into helping her write motions. It says that's not true. He can read though, so I don't feel sorry for him. The judge also knows that Sarah has been told this multiple times. She's raised this issue. So those are the receipts on that. Then, we're going to get nosy and dig into her financial business, right? Because, well, let's go back to her motion. So we had shared minor child indirectly made statements regarding the petitioner having a real job. So that the not doing contract work anymore, that's nowhere on the record that he was ever doing contract work. In the 2018 petition for the dissolution of marriage, he had a job. He listed his employer. He didn't mention contract work. So I don't know where she got that from. Respondent has documentation showing petitioner receives regular family support approximating $3,000 to $17,000 or more per month in past years, where he stated zero on his submitted financial affidavit and mandatory disclosure. So she has documentation from where? I'm pretty sure Brian didn't send it to her. She can't break into his mailbox because she's incarcerated throughout the duration of these proceedings. And the only person left who would be in the household would be her son. So is she encouraging him to open up mail and get this information? Like, where would this be coming from? I know some of you guys said she had people going to Brian's house to ask about money. Were they breaking into the mailbox? Federal crimes, either way. Even if her son is doing it, she's having her son commit a federal crime. But again, this feels like she's breaking the parenting order if she is in fact getting that from the son. This is not, as she said, it's not listed on the financial affidavit and mandatory disclosure. So where's she getting that information from? And instead of writing this motion, all of that evidence that she has needs to be entered into discovery so that it can be talked about at the trial and the judge can decide based on that. So the legal standard. So I guess there's a Rosen v. Rosen and a Rosenblum v. Rosenblum, right? Because we had that in the other, let me just go back. I'm looking at this. Yeah, Rosenblum v. Rosenblum is what dictates that he can't be, the motion for contempt can't be held until his motion for elimination or reduction is heard. Now we have Rosen v. Rosen, holds that financial affidavits and supporting documents must reflect all sources of income, including gifts and support from others.
So my mama told me what's good for the goose is good for the gander.
So let's take a look at what Sarah filed for her finances. Did she put any of her gifts in there? So she checked that she was unemployed. It's all zero. Gross salary, wages, bonuses, commissions. She doesn't even put a place on here for gifts, but everything is zero. And then she has some ridiculous things like monthly alimony actually received, unknown, which she put it in received. Okay, yeah, this is the income section. So unknown, it's that silly. You know if you are getting monthly alimony since you've been incarcerated or for the last 3 years. It's a zero, ma'am. Knock it off. From this case, unknown, TBD. They're not asking you futuristically. They're asking you in the current moment, the actuals. So here is where I would think she would put gifts. Any other income of a recurring nature and add the source. She put zero. We know she's getting money. You and I have recently looked at where Lana sent her money, Peter Gunthel sent her money, her pastor had sent her money, people were sending her money. So we have this. We see here, this is her spreadsheet, November, you can see it here, of her payment. So just in November alone, she received $360, right, from Diane Kay, who I believe is her pastor or whoever the religious figure who used to work at the jail she was at. And these are all 2024. So this is Lana sent her 125, Peter sent her 175 in that month, and her brother Philip sent her 50 in that month. Yet she has zero. But then, boys and girls, I have an extra treat for you guys. Hang on one second. Let me find it. I just realized today while prepping for this that I have actually more than her November data. Let me show you the raw data because this is a pivot. So these are all of her, I filtered because I was trying to just verify my numbers. But you can see these are the payments. I will do a drop down for the date range so you can see what we're covering. You guys see that, right? Let me move. That still looks really tiny. Okay, hold on. Let me just, because I want you guys to see this. This is that good. So if I filter it, you guys will see it covers 2024, January through September. So we're not covering all 12 months, right? So we're missing October and we're missing all of December except for the first 3 days. I'll show you in a second. I'm trying to not make you dizzy. So I just made a pivot on just that alone of like who made deposits and how much. And again, this goes to October. So that's why you do not see Peter on here yet. His first payment, or this goes through September. I'm sorry. His first payment was that I can see was in November. I don't have October. So it could have very well been. We'd have to look at the messages to see when the Delapines first reached out to her. But look at this, guys, $2,484 here. And then, I gave Sugar Bear my phone. What did we say on the other one? So 2,000 plus the 360. Oh, the calculator doesn't pop up. You're going to have to trust me, or you can add it yourself. Plus $2,484. So she received $2,844 in gifts in 2024. Yet on her document, she has 0 for other, right? We've got Ashley Harris. I don't remember her. You guys may, but look at this. Brian Boone. Yeah. The monster truck? There's the monster truck. So Brian Boone, $690, guys. She's saying he sent her nothing. Okay, give me 1 second, please. $690. Brigitte sent her $50. We know her from the text messages. Christina sent her $265 through September. James Owen sent her $100. He just met her in September, so he was like, let me break you off. Cabri Baptiste, I don't know who she is, $29. Lana sent her $880. I'm glad I did not find this while Lana was alive, but she might be surprised. Although she did say others were sending her money and she sent it out. Might that be the Delapines? Philip sent her $325. Stephanie Smith sent her $65. And then Tanya Hager sent her $20 for a grand total of $2,484. Yet here she is demanding that Brian have full disclosure because it's required, including gifts and support from others. That's rich, guys. That's rich. Please hold. Okay. If this is a little choppy, I apologize. I've stopped and started several times today. So it feels like Sarah might be projecting like all the things that she's doing. She's accusing Brian of doing with no proof, but we have the receipts. Sarah is lying like a rug. Okay. So let's get back. It's interesting is not even the right word. So then she goes on for argument, petitioner's refusal to answer interrogatories. So this has already been sorted out. The judge denied her motion to force him to answer the interrogatories, but I just highlighted this. She says, particularly with regard to equitable distribution and potential support obligations. So that is moot, actually, because equitable distribution was originally decided in 2018 when they got divorced, and they already agreed to all of that. So it's not just the equitable distribution of like cash, but what would happen with the house. She got her equity and that was it. And she had no further involvement with the house, which makes it kind of rich that she then asked to know how much he sold the house for and what he did with that money. It's none of her business, right? And then also potential support obligations. He's asking for a reduction. His original request for a reduction was because of a change in circumstances, mainly because she unalived her boyfriend and was likely to serve life in prison, which now we know in this document that she's already convicted for life. So I just have a question mark there, like, why, Sarah, why? So here, evidence suggests petitioner is either employed or regularly receiving substantial financial assistance from third parties. These funds must be disclosed per Florida law. She doesn't cite which law, but it also applies to her, right? She's doing that finger thing, like, what is it? What is for me? What is for thee is not for me, or whatever that saying is. Like, she hasn't disclosed any third-party assistance, and she's received it in the thousands, and it's public record, so it's kind of dumb. So any other income of recurring nature identify sources, right? Petitioner has left this item blank. So did respondent. So did respondent. So this one threw me for a loop. These next three, you see my question mark. So she's saying in reviewing petitioner's credit card statements. So I know when I spoke about this, some of the members were like, well, Lana gave her credit card statements, but that was from 2022. So it seems that Brian has supplied credit card statements for April 26, 2024 to March 27, 2025 because of when he submitted it. So I guess no, but that is 12 months. We talked about this before. So per month, the petitioner received between $3,000 to $17,000. That's not how credit card statements work, right? Credit card statements is like you're taking out a small loan, I guess is how I want to say it. You're taking out credit. So it's not you receiving the money. So I'm trying to surmise again that what she means is that the bill is being paid for 3 to 17,000 and somehow she gets that to be income. But and we'll look at his statement, because he's not counting this as he has debt for a credit card, perhaps maybe it's being paid by the trust or his parents. So she's counting that as he's receiving that as a benefit, but he could be an authorized user. He could be an authorized user on there, right? So then it's not like he's using their card, but it's not his money. For years, my daughter has been authorized user. I don't think she is now on my cards. Mainly we did it when she was a teenager to help her credit score, right? Because it lengthens the time of her credit score and available credit as long as mom didn't have it maxed out. But so combined total for all months in this time period was calculated at over 39,000. So is she counting each time the $17,000 was paid? Because there's also those of us who run up a credit card bill and then we pay down the bill so that we have that amount of available credit again, and then we're off to the races. But it's not like a new 17,000. We're just recycling it. Do you know? So she's saying that this should be counted as income, even though she has it in air quotes, so that should be reported on a non-air quote, so a regular income tax return, right? She's saying he put non-existent. Respondent is compelling petitioner for additional evidence and truthful, which is lawfully necessary. Oh, the words. Words are not your friend, Sarah. Less is more, honey. To prove her defense of contempt. So I think she means to prove her, because defense of contempt would mean she was being held in contempt and she's defending it. I think she's asserting that he's in contempt, which cannot be heard until his motion is heard to reduce or eliminate. So here we are in that circular conversation again, including why he was not working for over 3 full years. Maybe because he's all over the news and YouTube talking about his crazy ex-wife who put her boyfriend in a suitcase. Maybe that's why it's hard to get employment. But he doesn't owe her an explanation for that, right? The fact is he doesn't have a job, and those are the facts. That is truthful. I don't know what other evidence you need that you don't have a job. Expenses detailed on the financial affidavit provided by petitioner do not include the petitioner's regular purchases of alcohol, cigarettes, video games, Uber Eats, football games. So I don't know that it needs to be itemized to that detail. So we're going to take a look at his current financial document that he submitted. Love you, FOIA. Or this is just actually court records. So here's what he submitted in April of 2025. You guys can still see that, right? So still unemployed, 49. We'll go through it more, but he has... So here are all his household estimates. They total up to $1,200. They include things like the electricity, water, garbage, sewer, telephone. I'm wondering if this is just the mobile phones. $250 for 2 mobile phones. Probably doesn't have a landline, I'm guessing. And then fuel or natural gas is low. It's Florida. I mean, I guess his stove could be natural gas and his clothing, the dryer for the clothes, but it's low. Monthly repairs and maintenance on the house, 50. Miscellaneous household for is 50. 400 monthly food and home supplies. So he could be including his Uber Eats in that number. It doesn't have to be itemized, or he could be including it in monthly meals outside home. I know what you're thinking. It's outside home, but like takeout and delivery is technically prepared outside of the home. Where you consume it is something else, right? So monthly cable TV, which also probably includes internet. Okay. Automobile, 155. Monthly allowance. So for the child, common to both parties, which means Brian is only paying for it since Sarah is incarcerated. So that's 155. Things like vitamins, beauty parlor, keeping his hair tight, clothing and uniforms, cosmetics, toiletry. So like, acne medicine, toothpaste, deodorant. 155. There, it's reasonable. My 14-year-old daughter, when she was 14, no way. Monthly pet expenses. So remember, Brian testified that they had just gotten a new dog and he was crating the dog, which is the reason why the time that it took from him to get to Sarah from his house on the day of at the crime scene was because he was crating the dog. So that's $50. So here, monthly payment to creditors. There's no creditor. So whatever credit card she's referring to, he doesn't make that payment, right? Because it says made by you on outstanding balances. Monthly expenses. So his total monthly expenses are $1,560. You will see that Sarah's are $750, and she's in prison and she's single. It's almost comparable to what his half would be, right? Which is weird. So trust account, the checking account has 1306. The closing statement was 327. So that was the balance. I don't know how it's set up. I think before I referred to it as having 1306 monthly, but I misspoke. I'm not sure how much he gets and when it comes in. They're not asking him that. So he's giving the balance as of the last statement prior to filing this. So this, he might have to eat, but he's saying money lent to Sarah owes petitioner in excess of $20K. I doubt he got a promissory note. I doubt she's going to cop to it, but we just saw where he gave her $690 alone the first 9 months of 2024. So, and he had her car stored. He had all these other things, which are outside of the marital agreement because she's going to bring that up too, right? So then he's got his 401k for $57,749, which is rather on the low side because he is, what did we say, 59? I can't remember, 50 something. And if his average annual income is 60, like if you're going to retire, you would, like, just say for the sake of this discussion, you'd want to have the 60. It could be less because you're not, paying the same amount of taxes, et cetera. But again, for this conversation, 60. And so that's not even a year of retirement for him. The good thing is he can take money out of that if he should need it. And he may well have been, which is why it's only 57, because he's severed employment. So it's not like he has, the ability to take out a loan and then pay it back via payroll deductions, right? But that was the balance as of March 31st. On his disclosure, he mentions a different 401k. I'm not sure why he's separating them. Perhaps the other one was what was excluded from in the divorce. I am not sure. But it's like a Wyndham in the financial disclosures, 401k that he has mentioned there. So here he's got that. Home furnishings, $5,000. So all of his assets total up $410,000, right? So then we go into his debts. He has no mortgage on that home. He owns it free and clear. He has no, so this is blank here, but there's a zero here to indicate that is because all of these are zero. So rather than repeating it, whoever did the sheet was like, the total is zero. So no auto loans, no bank or credit union loans. So his net worth is the 410. including the 20 that Sarah owes him, but he has no liabilities. So not bad, especially for someone who hasn't had a job in 3 years. You go, Brian. So then child support guideline. Hang on. Liberty. What is happening? So then let's go back over to Sarah's financials, right? So she's not counting income of a recurring nature or the source. And maybe, she's pedantic. She's getting tied up on recurring. But she does get repeat payments because what I showed you was a pivot table summarizing what each person gave her altogether. So I just feel like she's cheating. She should be counting it. So her monthly deductions, which is laughable because she pays nothing. So it's all zero. But this she puts unknown, court-ordered alimony. Sarah, do you owe someone alimony? Why are you putting unknown? You should know if you owe someone alimony. From this case, unknown. You should know that you don't owe Brian alimony in this case. Then here she has unknown TBD, present net monthly income. Ma'am, what about the $2,000 you got in 2024? You know about that. Average that out. I'm sure you're getting money in prison. Average that out. Total monthly expenses unknown. You don't know what you've been spending in 2025? You have no idea? Well, you do. I'm being facetious because it's in this document and we are going to look at that. So total monthly expenses, she puts unknown from line 28 above, but then she goes, you already know how I feel about this. This makes no sense. This cannot be equally an asset, and then later asset attributable to both of them, but only the total is attributable to her as an asset. But you don't have it, so how can it be an asset? And then down here for liabilities, she also has it is just a liability for Brian, not according to Brian. Brian has nothing to do with that Kia Sorento, and there's a 2018 dissolution of marriage that agrees with him. No storage unit is mentioned at all in that dissolution of marriage. So if you have some paperwork saying that he is going to pay you for that, that is a separate civil motion that has nothing to do with family court. But see, that's how you know, like there's a subtext. She thinks it is because it's her ex-husband, and she thinks he owes her because they have a child in common. Do you need help putting your house shoe back on?
Yeah.
Okay, I think I can help you with that. Let's see. So she's telling on herself. And then again, contingent assets, it's hers. If it's your asset, why are you reporting it? You want that to be factored into how much he doesn't owe you? Like, what is your goal? She doesn't have one. She's always like victim-y. So of course the judge should assume she's being abused somehow by her writing that. So household, here she's going to go into her average monthly expenses. Food, $250. We're going to actually, let's look at it now, because when she was in jail, she ran up quite the tab. Do I have that pivoted? Yes. Move myself over here. So here we have her Zuzus and Wham Whams list from jail. I have pivoted it, but I know I've got some other data nerds out there, so I will show you what I pivoted. These are covering the dates of 2024 from January through November, and then let's just confirm which days in November, because I'm not sure if I have all of them. Goes through November 28th, right? So that's the data that I've included in our pivot. And so I made that into a pivot table. We have that here. She has spent $264 in all of 11 months of 2024. But on her financial data, she's saying she spends that in a month. Unless the prison prices are ridiculously different from the jail prices, I'm calling bullshit. What has she spent the most on, you're wondering? Well, I have that for you. She spent the most on candy. That's where her money is going. That is what she and Peter are fighting Brian for, is candy money. $139. She had 26 Three Musketeers, 35 Butterfingers. She got a Baby Ruth. It's zero here because she returned it. She spent $15 on manila envelopes, which I'm surprised it's that low. She got 27 of them. For her hygiene, she spent $12.74. She did buy body wash and shampoo, fresh scent, 3 of them, but she returned them. I'm guessing probably when Christina left, she gave her some things. That's just a guess, right? But her health and beauty for those first 9 months or 11 months through the 28th of November, $12. Her second highest grouping was bakery products. So she's got Pop Tarts, 38 of them, packs of 2. So 76 Pop Tarts she got. A Texas cinnamon roll, 18 of those, and 1 apple cinnamon honey bun. I guess that honey bun wasn't that great for $2. And then her sugar substitute. She got 43 packs of 10, so 4,300 sugar packets. That's where her money is going. That is what she is hounding Brian for. That is what she is saying. Reduce the amount of money that is in the household where my son lives so I can buy these things. Yeah, I gotta calm down. I know. I hear you. So let's get back to her financial stuff. So she's saying $250 for food is what she's estimating that she has spent per month. What happened? You need a kiss? Is that an owie? No. Well, it doesn't look like it needs a Band-Aid. Hopefully it'll be better. Okay. Another kiss? Okay. Oh, I'm not kissing the right place. Okay. Can I have a kiss on the forehead? I love you. And then, so gifts for holidays, child expenses. She's saying $100 a month is what she spent, because these are not projected expenses. She's saying estimate, but it's supposed to be what she spent. And she filed this May 30th with the court. So it's going to be for January, February, March, April, May, right? She should have actuals. She got to prison 12/30/24. So other communication 200. So I don't know how that works, but I would think Brian would already be paying for the communication as a child expense because they're collect calls. Y'all let me know. Is there some prepaid card somebody could send her? Either way,
She wants her ex-husband to pay for her communications with her son because she unalived her boyfriend.
Insurance, she doesn't have clothing, $50 a month estimate. Medical, dental, uninsured, $15. Other hygiene, $50. We just looked at what she spent last year. Writing items, $20.
She should never be allowed another writing item again in life.
So she's spending $70 a month on that. So payments to creditors, the Department of Corrections. Again, she wants to count. Should Brian pay the Department of Corrections because you don't have no act right?
Man.
So all of that together totals $735 per month. There's 12 months in a year. We all know that. So I am going to $735. He's locked himself out of the room. Well, the air conditioner is sucking it closed. He can't pull it open against the air conditioner. So $735 times 12, $8,820 a year is what she is saying her expenses are. $8,820 a year. Even though, I gotta look at you, even though she is under the care, custody, and control of the state of Florida. Please hold. Balls of a burglar, guys. Balls of a burglar. That's all I can say. That is not including, you see on the side here, she's got clothing is charged quarterly, limited quantities. I don't know if I think this is all related to clothing, fluctuating prices with vendors. It can't be that much of a fluctuation. Fluctuation puts in mind like great changes. I would say there might be a slight variance. Anyway, so we'll give her $735. We're not going to try to figure out what that other kerfluff is about the fluctuating prices. So $735 is what she's alleging that she is paying as an estimate per month. When she writes this, it is May 30th that this is submitted. So I'm going to count May as one of the months. She moved in on 12/30/2024. So 5 months times $735 is $3,600. Can you guys see that? Maybe not. $3,675. Where the hell has she been getting that money from? She does not bother to explain that in any of her statements. And then she puts a child support guideline worksheet is or will be filed in this case. This case involves the establishment or modification of child support. She has not to date submitted that to the court. So where is that, girl? So you got the parenting plan due. You have the child support plan. What's it called? Child support guidelines worksheet is due because you're asking for child support. She's saying she's going to file a child support guideline worksheet. So we haven't seen that hit the docket. And she didn't do like the affidavit, the disclosure, where she has to say all of this is true. What's that thing called? So many documents. I don't have it open, but there's another one where you have to attest that everything is true. So that was her financial document. Where do I want to go next? Let's look at Brian's numbers because actually, let's go back to her motion for contempt. So what else is she saying? So that he's currently holding employment. Petitioner has left numerous entries blank, entered zero, or stated non-existent, which respondent can prove otherwise. So instead of writing this motion, you just have to prove it otherwise, right? When you put your case in chief on Ms. Boone, bring those receipts. Also, respondent would like to bring to the court's attention, spell check is a thing, that petitioner refuses to complete visitation form. So they talked about that. The judge ruled on that in her last order, saying even though there was no motion, the petitioner voluntarily communicated that he had already done that and he would follow up on it, not required by the court. The other thing, so the credit card statement. So let's go to Brian's and look for, because he's not claiming any credit card debt at all. And he actually looks good on this paper as far as like financial stability, meaning he's not carrying debt. So he's 49. He's a software developer. He's unemployed. This has been the situation since 2022. He filed this exact form in 2022, even though Sarah and Peter are alleging that he never stated a change in financial status. He was unemployed. He did file that. You and I have looked at it multiple times now. He's head of household, so when he does file his taxes. So I've redacted his address. But here are his monthly things. Also estimates. Electricity is $180, water, garbage, sewer $50, monthly telephone $250, which, oh my God, I hope that is including the collect calls, because I'm thinking he has probably a landline. Not everybody does, though. I haven't had a landline since 2014. Haven't had cable since 2014. So, no. Since 2011, I haven't had cable. In 2011, I haven't had a landline. I was thinking of when I moved into that place, or when I moved out, but when I moved in, I never had that installed. So he may not. These may just be the two mobile phones. One for him, one for son. Fuel, oil, or natural gas. So that's for the household. Monthly repairs and maintenance on the house, $50, miscellaneous household. So, and then monthly food and home supplies. So he has $400 here. He could be including his Uber Eats that she's so hung up on in that $400. He's not required to itemize his estimated monthly expenses, like by vendor. Monthly meals outside home. He also could include it here. I know it's delivered, but it's prepared outside the home, so it's still considered takeout. Monthly cable TV, and I'm guessing that also includes internet. It's just probably an old form. So his subtotal for that property, $1,200 a month, which is really, that's not bad. That's not bad at all. Automobile, so he pays for gas and oil, $50 a month, $5 for auto tags and emission testing, so probably $60 a year, and he's averaging it out to $5. He's calling it an estimate in case there's a variance. Insurance on that car is $100. Then child, monthly expenses for the child, monthly allowances, and it's common to both parties. So we know Sarah's not contributing. So this is 100% coming out of Brian's pocket. Clothing and uniforms, $50. Entertainment, so movies, parties, things that teenagers are. Yeah, 14 is a teenager, right? Teenagers like to do. Vitamins, keeping them healthy, $5. Beauty parlor, barbershop, keeping them nice and tight, $5. Cosmetics, toiletries, sundries, so toothpaste, acne medication, whatever, deodorant. So $155, very modest. If that would have been for my daughter when she was 14, baby. Although it sounds sexist, but girls are more expensive. Hair, nails, all that stuff. Yes, even at 14. So monthly pet expenses. You remember they had just gotten a new puppy when Brian arrived at the crime scene, because he said he had to crate the dog before he came over to Sarah, and he kept telling her, call the police. So monthly payments to creditors, only when payments are currently made by you on outstanding balances. He has nothing here, but Sarah is alleging that she has his 2024 credit card statements. So I'm surmising, not smizing, this is not Tyra Banks, this is Tanika's 2 cents. I'm surmising either it's being paid out. Well, even if it were being paid out of the trust, it would be attributable to him. So maybe his parents pay that credit card bill. So maybe that rotating 17,000 is, if it is rotating. We don't know what Sarah read, because Sarah's comprehension level is not that high. Whatever it is being paid by someone else, because he doesn't have a monthly payment to that creditor. So his total monthly expense is $1,560. Surplus, he doesn't have any because he has no net income, right? So then we get into his assets. These are things that he owns outright or owns partially, like if there's equity in a home, it's his. So he has a trust checking account. Its current balance, it's as of closing on 3/27/2025. And you'll recall he submitted this like 4/25, so he didn't have well, maybe he could have had if his statement was, no, because his statement would have closed on the 27th. So that was the most recent at the time of this filing. The balance estimated 1306. How that trust checking account gets funded is not disclosed. My guess, his parents are like kicking him ins every 30 days or however it's set up. There's so many ways to set up a trust. And then they get, what is that? They get X amount of dollars that they get to gift to him or put in the trust that they don't get taxed on. I can't remember what that's called. It's been a while since I've been in the CPA office. Okay. Money lent to Sarah. So respondent owes petitioner in excess of $20K. So that cancels out her BS 18,000 that she had, which it doesn't make any sense. That thing just annoys me every which way but Sunday, because she has it as both an asset for both of them, but doesn't carry it down. So only the value of the asset is counted toward her. Then she also has it as a liability. Then she also has it as like a special asset. It makes no sense. And it's nowhere in the original marital agreement. It literally just falls out of the sky. You can't do that. You need some sort of paperwork that makes it involved in the dissolution of the marriage. Which she alleges somewhere in writing, I can't remember, that he agreed to do it, but he didn't agree to do it as part of the divorce because you didn't murder your boyfriend until 2020 and you were divorced in 2018. So that would be separate and apart, a separate civil suit. Don't get me started. Which, I mean, it could be argued the same for him for this $20K. Like, did he give her that money while she was in jail? That also is not part of this, but I suspect his intent is to like tally it against what he might owe her, saying instead of paying her the alimony, I gave her X amount of dollars for this instead of a monthly alimony, which is still squishy math, but He tried. So then he has his Merrill 401k, 5774. If you're sensitive about numbers, this is the time to click out because please don't come for me. I'm going to say, so this is the balance as of March 31st. It's a low amount. If you consider the fact, because Brian is older than I am, I'm 54. I think he may be like 58 to retire. And he said his average annual income is 60 to 80, right? So to retire, for every year of retirement, you would have your annual income or close to it. It doesn't have to be exact. You're going to pay taxes on it, but you're not having, like, if your gross is 60, you're not paying into your health plan and everything else that you would have been paying into while you were working. But just for the sake of this conversation, let's just say his goal would be 60 a year, right? He doesn't even have a whole year's worth of salary in his 401k to live off on. That's what I'm basing it on, that it's low. So he's not set as of now to retire at 65, right? So it's low, and he could be, because he is no longer employed, or I mean, she's alleging he is, we don't know. But let's just say he's no longer employed with the company where he started this 401k or finished this 401k, because he could have had a transfer. He can just take out withdrawals. I don't believe you can take out a loan anymore against your 401k once you are no longer employed. I think it's a withdrawal only. He could have, as I'm very, very, very familiar with, taken out a loan against it while he's still employed. And then that comes out, it's deducted out of your paycheck, whatever period your paycheck is, right? So then home furnishings, they're valued at $5,000. So his total assets are $410,000. So overall, because he has the house, he's not in bad shape, especially for an unemployed person. So then we go to his liabilities and debts. As it says, this is where you list what you owe. First mortgage, nothing. He doesn't owe anything. Charge credit card, nothing. He doesn't owe anything. Now, it could be argued he could have gone in and intentionally put in a 0 to clarify, but whoever did the math just put the 0 here instead of in every place. So that signifies each one totals 0. So therefore, each item is 0, right? So, okay. Charge credit card accounts, he owes nothing. Auto loans, he owns his car free and clear. Bank credit union loans, doesn't owe any. So again, that just looks at his overall picture is not bad. Just under $500,000 is his net worth. So I don't know where in her document, like, she's getting all of this. This is what really just has me scratching my noggin. So it says April 26, 2024 to March 27, 2025. So he submitted those credit card statements, right? But he's saying he doesn't pay them. He doesn't have a debt on them. Per month, the petitioner received. So maybe it's clarifying that, and she's counting like whoever's paying that bill as he's receiving that money, even though it's going directly to. But we don't know, because he could be an authorized signer on someone else's card, which is why he's not showing it as debt. So he doesn't have to count that as income because he's using someone else's card effectively. But she's saying combined for all months for this income. I mean, especially if it's being paid by the trust, right? I don't know what she's digging at there, unless she's trying to say he should have reported that as, like, would that be considered maybe a gift? But if it's by the trust, it's not a gift. Like, that's his money. I don't know. We need a tax person, a CPA. Hear me out. If you're hearing this, let's do a collab because I have questions. Evidence suggests petitioner is either employed or regularly receiving substantial financial assistance. So if he's showing those credit card statements, well, if it's not assistance, though, if he's getting it from his own trust, I don't know what she's barking up there. So we already know the judge said, knock it off with the interrogatory. She's not making them do that. She's gone on about the gifts and support from others, but she has not listed her own. So one more thing I want to go over. I'm going to call this video that she's violating the Parenting Act, but it's also, there's like, she's fudging or confused about the financial data. But that's I think the core of her ire is like, he's not giving her money. It's the send me money, send me money, send me money syndrome that she has. Because that's all her interactions with him are about. So petitioner's been unemployed for the past 3 years and has not filed income tax returns for 22, 23, and 24. We've gone over that. Some of you guys have said he should have filed. Okay. Petitioner has provided a copy of the general warranty deed for his property. He owns all deeds evidencing any ownership interest in property held at any time during the last 3 years. All promissory notes. So it's only the current house because no, he moved in 2023. Oh, but he doesn't have any ownership in the other one. He sold it outright. Okay. So all promissory notes or other documents evidencing money owed to either party at any time within the last 24 months. So he doesn't have a promissory note from Sarah for that $20K. All periodic statements, petitioner has provided statements for the following accounts and time periods. So he's misspelled trust, but that's what he means, trust checking. And so he's given 12 months worth of statements, April to March, April from 2024 to March 27th, 2025. Brokerage account statements within the last 12 months, so none exist. And I don't believe he has to include his 401k, but it's here because that was decided during the dissolution of marriage. Each party shall retain their own retirement accounts. So petitioner has provided statements for the following account and time periods. Windstream 401k plan. So I do have a question here because the other in the financial statement, Windstream 401k is not what he listed. Let me just peek because I don't remember off the top of my head. The other one is listed as Merrill. So I'm curious as to why he's showing one and not the other. But he's mentioned it here. He's given the statements. Maybe she would have already had the other statements. I'm not sure. That I do have a question mark about. So, or just a question. Petitioner has provided copies of insurance cards for himself and minor child, so he's paying for that. Although that is also not listed on his financials, so perhaps his parents are paying for that. If so, he's demonstrating his help from third parties. Respondent has provided copies of the party's final judgment of dissolution of marriage, filed June 15th, 2018, and supplemental petition for the modification of final judgment. So he's provided those copies to her. So her story, and he sent that April 25th, her whole story about she can't properly prepare because James Owens hasn't sent anything and the court won't send her anything unless she pays for it is bogus. She has what she needs because he submitted that with his filing as foundational document. So she's always a victim. She's always making some sort of weird excuse. And I frankly am not sure why, other than mental health disorders. But I would think the people that are surrounding her would try to talk some sense into her and say, look, explain it to her at least. Although, can they? Like James Owens didn't explain it to her that Brian didn't have to pay her. But Judge Kranick knew. If you watch the bashing Brian Boone at Sidebar, Judge Kranick calls it right out. He doesn't have to pay if there's a modification pending due to a change in circumstances. So what she's filed in these documents is false, just based on how the process works. Her motion for contempt cannot be heard until his motion for modification is sorted out. Period. Full stop. Let's go back to her accusations. Respondent believes petitioner is willfully preventing the minor child from seeing his mother. Petitioner is currently holding employment and has been in the 5 months prior since respondent began requesting the visitation forms to be sent. So where would she get that information if not from the child? Unless she has someone following Brian and he's actually going to a job, but his other job was remote. So his current one could be too. No, thank you, honey. So I want to go back to his financials. Let me just look at it. Maybe I don't want to go back. I've gotten myself distracted. So Sarah owes him money. He has the... No, I don't need to go back to that. He sent that in, signed it April 25th. I do want to show you what I believe are other mistruths by Miss Boone. We've gone through her Zuzus and Wham Whams for the year, gone through her gifts. Let's look at her inmate balance sheet. Now, granted, this is from when she was in jail before she made it to prison, but it should be a good like guideline, baseline for what her habits are. So there's a lot of booking fees, medication, $5, medication, so whatever her medication is. Order debit, so she ordered something for $114, something for $12. She got a deposit for $200 on the 26th of March. Return. But you see, she's ordering food and whatnot. It's $132. Return credit $679. So she returned something. Maybe at that Baby Ruth. She's ordered something here, $110 on the 29th of April. More donut? I thought we were going to share that donut. You want my half of the donut now? Yes. Okay, I didn't need it anyway. These are all, I didn't get it in a spreadsheet, so I can't do fun things with it, but just giving you an idea. Order for $54. Then here she is in May getting $200. Order for $34, order for $10, order for $44. She's getting a deposit for $200. Her daily fee of $225. She was sick on the 26th, May 26th in 2020. You get the idea. I'll scroll through it for those. Here's another one. So regularly, she's getting a deposit of $200 a month in the beginning, at least in 2020, which I suspect is probably from Brian. Order debit $110. Here she gets a deposit of $360. We could probably, oh no, I don't have the 2020. I was gonna say we could probably go back and cross-reference. You know I love some data triangulation, but I don't have that data. Order for $53. So she's not hurting, right? $58. I am going to skip, close your eyes. I'm going to skip to, or don't, if you don't mind the scrolling, I'm going to skip to 2024 because that's where our story begins, at least with deposits. Good Lord. You see, this is 59 pages. It's her entirety. And if you guys want, we can go through it in greater detail, just nitpicking it because it is a lot of data. But there's definitely, here's another. August, she gets $200 from someone, web deposit. Again in August, the end of August, another $200. It's not Christina because Christina doesn't get out until 2024. Here's another $200. So she's like, I'm pretty sure these are from Brian. You know, her brother can't afford it. So the way she talks to him is just not excusable, right? And the way that she berates him to other people and describes him. And she's got Christina and Lana calling him, you're doing the man wrong. He tried to do right by you. I don't know why he tried so long because I wouldn't have done it. You're not nice to him. 200. This is November of 21, December of 21, 200. Let's get to 24. Okay, we've arrived in 24. So she's got a $40 web deposit, $20 web deposit, $50. So we can see it's going down over the years. I imagine she'll experience that same pattern as she's doing life, right? The money she's getting today is probably not what she's going to get 10 years from now or 20 or 30. But she places an order in May, 46. It's $55 order, $52 order. I don't know enough about jail to know like if this is comparable to what other people are doing. If anybody knows, let us know, let all the lovelies know. I know some of you guys have paid your debt to society and are willing to share, and we appreciate that. She's got another deposit for $50, one for $30, $8. We're in 24. So if we get to November, we should see like Peter and Lana's deposits because Peter was like a 100 and a 75. So let's skip to November. So here's a 100. Lana also had a 100. So here's one on the 1st. I believe Peter had one on the 1st. Here's one on the 7th for $100. The $20 or $25, $50. So we're seeing it correlate with the data that we have on the other spreadsheet. Another $100. I haven't seen the 75, and now we're in December. Let's go back. Did I miss that 75? Yeah, here's the 75. We know that's from Peter based on the other spreadsheet. So she's been getting money, these cries, and it says 59 of 60. I guess I don't know what happened to 60. Oh, this even goes to January, which she was gone on 12/30. Oh, this is the check. So inmate cash released 5/25, inmate check mail. So they must have sent that to the prison with her to zero her out because there's a holiday in there, right? The first New Year's Day. So when she's saying she doesn't have money or no one's sending her money, she is not being honest. I have the visitation list, but I haven't redacted the son's name, and it's 8:30. I've been working on this for like 12 hours now, so I'm not going to do that tonight, because hopefully we can watch this later tonight. I've got to edit this. We'll see how long it takes. But I do want to look at that relative to her saying, she never sees it, because we heard in the text messages at the top of the video, the tablet messages, that he's never allowing the son to see her, and she's holding out, waiting for the Christmas presents in March. Can't have the visitation until then. So I just want to go back and fact check her, because she speaks in hyperbole, and we're supposed to figure that out, I guess. I'm saying that it's a nice way of saying she exaggerates and or lies, like as she retells things. But let me know what you guys think. This was an interesting rabbit hole. I thought it was just going to be about the parenting plan, but looking at the financials and those accusations, it seemed to be so much more. There's more data. I don't know how long this is now, because I've made 3 separate videos because I've been stopping and starting. So I want to stop now so that we're in a good place. But lots and lots of documents. Let me know. I'm really curious about what your thoughts are. Does this surprise you at all? I was actually kind of surprised, especially when I found that I had the data for all of through September of her deposits. I don't know how I missed that before. I was surprised that she got like roughly $3,000 donated to her, but she's always crying broke. And maybe because as the deposits started to decline, she could see the pattern on the wall. So she's like loading up for her next set of people she's going to dupe. Let's be honest, right? For the next stooges that come along. What do they call it? The next marks that come along for her? But I'm actually surprised that she had so much money and she spends so little money. So that was my other thing. Is like, is she paying hush money to someone? Is she paying money like to keep people off of her, giving away money? Because there seems to be there's a discrepancy, I don't know if discrepancy is the right word. That's why I'm struggling. But between what she's receiving and what she's spending, what is she doing with that money? And we see she's giving it away. Something has happened to it, because it was only $35 to zero her out at the end of the year when she transferred. $34.65 specifically. Where's it going? Does she need it because it's like protection money? Something is missing there. So let me know what your thoughts are below. This will probably be a premiere, so we'll talk about it in the live, but then the replay crew, you're always welcome. I always check the comments, especially the first 24 hours after the video premieres, because you guys have great insight, and I definitely need your insight on this one. So let's sound off. I'll talk to you later. Toodles.